Good afternoon, or is it evening, Ms. Chesiwe?
Good afternoon, CJ.
Are you well?
I'm well.
Yes. I'm trying to check where to begin, but maybe let me apologize to you too. You ought to have been interviewed yesterday. We said we will interview you today at 4. I beg your pardon, at 2. And it's only 3 hours later that we're beginning with your interview. We apologize to you for wasting your time and maybe even causing you a measure of nervousness. Let's just try and start at the beginning. Where did you obtain your degree?
My first degree, LLB, I obtained at Vista University.
Yes.
And then the second degree I obtained at UOFS University.
At?
UOFS, University of the Free State.
Yes. And what about diploma in labor?
The labor diploma I did through a correspondence college, Oxbridge College, which was a correspondence course.
Yes. Now, just in your own words, tell us how or why you believe you are ready for this position. Don't rush yourself, just explain why you believe you are ready. What is it that prepared you for the position of High Court Judge?
Thank you, CJ. CJ, I think I'm ready due to the following reasons. Since I graduated in 2002, I've been in the legal field, whether it was in a family advocate, whether private practice, whether in the acting as a magistrate, acting as a judge for 2 years in different divisions, North and South Gauteng in the Free State Division. And I have done so far with my acting stints, I've performed well with the judgments that I have been writing under the guidance of my senior judges. And the exposure I've had for the past 2 years, I think has prepared me well to be able to find myself on the bench.
Yes. Now, you would know that there's a particular case that you were asked about at some length the last time you were here.
Yes, Vijay.
Would you want to deal with that?
Yes, I would greatly love to do that.
Please take your time.
What happened in that case, and it slipped my mind on that day. As the trial went
It is a rape case,
the
isn't
rape
it?
case, yes,
Yes.
the rape case.
And can you just remind us what the concern initially raised by the MEC was? So that as you address it, even those who might not have been here at the time, like Judge President Japi, can have a sense of what the issues were.
The concerns that the MEC raised was that the trial court gave the accused life sentence for the rape of a minor child. And then on appeal, we reduced it to 15 years. What happened in that case when, during the appeal argument, the state at the trial court considered that as the trial started, the accused was not informed of that the prescribed minimum sentence will be applicable. And at the end of the trial, they realized that they didn't tell the accused that he might be sentenced to life. They didn't explain him the implications of the prescribed minimum sentence. And at the appeal hearing, the state considered that. And the state said, yes, we are aware that he was not told of the prescribed minimum sentence applicable in this instance. As a result, it was kind of like violation of his rights to a fair trial. In that way, they realized that the life was unfair for the fact that he was not made aware that he will be facing life sentence if the court finds him guilty.
Yes.
That was part of the things that I forgot to mention, and the state considered that also.
Now, who were you sitting with? Was it another acting judge or a permanent judge?
I was sitting with a permanent judge.
What experience did that judge have? For how many years had the judge been permanent?
The judge...
More or less.
As a judge?
Yes.
I would say was recently appointed, maybe a year or 2 appointment.
Yes. And Do you have children?
Yes, CJ, I've got 3 children.
Now, is any of them a girl?
I've got 2 girls.
As a mother who even has girls, what would you say to a criticism that says, in that manner, you demonstrated disregard for the children of the interests of women or of children, and maybe the criticism that seeks to suggest that you really don't care that much about the well-being of women, the violation of women or girl children?
CJ, the criticism would be fair, but at the same time, I would say, when you look at the Constitution itself, Section 35, that says every person has a right to a fair trial. One has to balance those rights of an accused person as well as the rights of the victim. One does take cognizance of the fact that rape is happening in the country, but at the same time, one shouldn't be blinded to the fact that there's also the rights of the victim, of the victim as well as the rights of the accused to be balancing out on each other, to ensure that the accused himself is also not given a trial that is not fair.
Do you get a sense that the public understands these nuances, or has the abuse against women and girl children been so rampant that the feeling is that for rape against minor children, you must really go as high as possible?
The public, if one listens to the public, one gets the sense that that's what the public wants, that the accused must be sentenced as harsh as possible.
Yes.
But at the same time, we're aware that the public opinion and public interest must also be balanced, because sometimes the public is not aware what the law says.
Yes.
All the public knows is that this is what is happening, this is what we see, and this is what must be applied to. They are not aware about the things that happen regarding the rights of an accused person as well during a trial process itself.
Yes. Do you regard your approach to this matter as an error, or are you satisfied that you dealt with the matter as, according to you, circumstances demanded that you should?
CJ, as circumstances demanded at that time, I felt I dealt with it well, for the fact that when it came to light that he was not informed of his rights, that the prescribed sentence would be applicable. So under those circumstances, I feel I dealt with it well.
Yes. Now, if criticism were to be to the effect that you lack judgment in that matter, what would you say?
Criticism is one of those things that do come to judges, because if you don't get criticized, it means you might not be doing well. So criticism will come to any person, to any judge, and one must accept the criticism as part of building you, part of maturing you, so that you know that in future something like this happens, you're able to handle it other way. And the fortunate part that we have, where one does these kind of things, where your judgment might not have been properly applied, we have your next appeal, where the person or the state can appeal the decision of what you've given and take it further. So
Yes.
one cannot be naive and not accept criticism. Criticism is there and one must accept it as building you.
What, if any, lesson have you drawn from this case, coupled with your previous interview?
Lessons that one has to learn, or one has learned, is that any matters that come before you, especially when it comes to rape issues of minor children, one must look at them very seriously and look deep into it and see whatever you're going to decide will be what is expected of you as a judge.
Yes. Yes. Any other thing you want to say before I hand over to the JP in relation to your suitability for appointment?
Any other thing that I would say is that what I've learned so far through specifically the 2 years of acting that I've learned a lot, and I'm still learning, and I'm still prepared to continue learning, because being a judge is not something that happens overnight. It's years of experience that comes along with it.
Yes.
So, as a person, as you grow older, you learn more. So I believe with continuous learning and continuous being in this position, one will get and improve as time goes on.
Yes. JP?
Thank you, Chief Justice. Good afternoon, Ms.
Good afternoon,
Chesiwe.
JP.
When did you start acting in our division?
My first time I started acting in the division was in 2012,
2012.
January to March.
Yes, and the JP at that stage was JP Musi, isn't it?
JP Musi was the one who had called me the first time.
All right, and when were you invited again?
Then I was invited again in 2016,
In 2016.
January.
Yes, and you have already indicated that you acted for 2 years. This is now your third time at the JSC, isn't it?
This is my third time at the JSC,
Yes, the last time you were here were in the October interviews.
October interviews.
Would you
Correct.
say there's any additional experience that you have gained since your last interviews? And if that is the case, what experience is there?
Yeah, I've gained extra experience because when I left here, I continued to act when I left the October interviews. Then in February of this year, I was at North Gauteng High Court, continuing to act. March this year, I was back in the Free State Division acting again. So I feel as the months go by, every time I continue acting, I gain more exposure, and this builds my experience and gives me more confidence.
Are you satisfied that through those acting stints in the Free State and in Gauteng, you have now received exposure to all aspects of the law, and that you are comfortable that you can deal with any case that is allocated to
I'm
you?
definitely comfortable that I can deal with matters that come before me, and the experience that I've been given over between the two divisions have built that experience very well.
Thank you. Thank you.
Thank you, JP. MEC?
No, thank you very much, CJ. Most of the questions that you raised, I think has covered me very well, except to say also, thank you very much, Chesiwe, for showing interest. Just one little question. with
Sorry,
you.
MEC, if you could draw the mic closer so that you can be audible. Thank you.
No, I was just saying that just for your own insight with regard to the experience, I have realized that you've also done the labor law.
Yes, MEC.
Yeah. What is your understanding with unfair dismissal?
My understanding with unfair dismissal is when a person who's being dismissed, where it can be procedurally not, when procedures was not followed, when a person is just told you are be dismissed, and the procedure was not followed within the employment services, it will be regarded as unfair dismissal.
What are the key components of one to be referred to be unfair dismissals?
The key components, if I can recall, because I hasn't done labor in a long, long time, would be whether the person was informed, why he's being dismissed, and the reason for the dismissal, and if there was no disciplinary set hearings before the dismissal.
If I put it to you that there are two components of unfair dismissal, which is substantive unfairness and procedural unfairness, what would be your comment?
I would say you're correct, MEC.
Thank you, CJ. Thank you.
Thank you, MEC. Commissioner Msomi?
Thank you much. Thank you so much, CJ. Good afternoon,
Good afternoon,
Ma'am Chesiwe. I've got just one question, and I think it's going to require you to explain one or two things. And it's a media coverage relating to a matter that you had in January, and it's contained in the document prepared by the Democratic Governance and Real Rights Unit. There are two issues that they raise in the matter relating to Richard Kuduka. Does that matter ring a bell?
Yes, I'm sitting with the file right in front of me.
Yes. The issue that is made out there is that you say, and I quote, "It is an extremely serious matter for a court to intervene in decisions that were taken by the elected representatives of an organ of state, and that if an open court has to intervene at all, it should be done in extreme circumstances. What did you mean just by that quote? What were you talking about?
In that aspect, I was talking about where institutions that has been set up to do certain things, and administratively they've done what they're supposed to be doing, where they have followed their procedures with regard to that specific part of the tender part, because it was a whole tender thing that was happening. So those kind of, where that kind of body has been set up to do these kind of things, and there was no misdirection, there was no irregularity, there was nothing unbiased or unfair. It is quite wary for the court to intervene where the procedures was followed properly in these instances.
So broadly, under what circumstances can a review decision be made? What will be the consideration of a court of law broadly in order for you to be able to review a decision and set it aside, either in terms of parja or common law?
Broadly will be simply where the whole process was unfair, there was an irregularity, there was biasness on the part of the body that was doing the tender, for example. So if the other applicant in this case is able to say to the court, this is what has been happening, this is what was done, then the court has to intervene and say, yes, in this case, you didn't follow the right process to attend to this matter.
The issue that is being made out of this media coverage, and I think you have an opportunity perhaps to explain yourself now, is that you said in the same vein, there were strategic considerations that gave Malembe or her trust advantage, despite their considerably less costly bid. And then the media says, Chesiwe's ruling does not elaborate on what these strategic considerations were. And then they go on to make an allegation that Malembe was the daughter of the province's premier. What do you have to say to that? If a member of public were to ask you, as they are, what strategic considerations were you talking about? And why did that not persuade you to rule otherwise? Thank you.
Thank you. The FDC, which was the first respondent in this case, in their place they've got supply chain policies, management assets policies, how to dispose their policies, and what criteria they use when they choose their tender bidders. So in this case, the strategy that they used in terms of their papers also is that the respondent, the third respondent in that group of category that they had was the one who had the lowest qualified in terms of the group. For example, it was a BEE, qualified in terms of the BEE and qualified in terms of their disposable supply management chain assets, disposable of assets. So their strategic consideration was mostly with regard to the whole BEE concept, how to empower where, in terms of their supply chain and the requirements that they put in the adverts to say what are the requirements for the adverts of disposing those assets. So the second part that you say, the ruling of the daughter of the premier's daughter, when the application came before me, I had the facts, I had applicants, I had respondent, I had no knowledge of anybody's daughter, premier's daughter. So I applied what I saw before me, and if one looks at the papers, the founding papers of the applicant himself, the applicant talks that he went to the MEC, who was then MEC Zwane, and the tender date was extended, and from then on, the MEC told him, me and the premier would not allow you to be treated like that. But in the applicant's papers, he doesn't state that. There's a confirmatory affidavit that says the MEC confirms, I said you will not be treated like that by the first respondent. So there's a whole thing that came out of the founding papers of the applicant, and with other aspects. For example, the applicant had meetings with the first respondents' employees after hours at Wimpy's and so on. So there's a lot of things that the applicant mentions, but the issues of daughters, of premiers, and all those things, before me, there was no such things.
Commissioner Fori?
Thank you, Chief Justice. Good afternoon, Mr.
Good afternoon,
Chesiwe.
Mr. Fori.
Chesiwe, I assume that you've seen all the comments made by the interested parties and the law bodies.
Yes,
And I wish to particularly refer you to the comments made by the Black Lawyers Association.
yes,
And I assume that you've read that.
I've read that.
If I may just quote some of it to you. Ms. Chesiwe's time in the legal profession is very limited. She was admitted as an attorney on the 9th of June 2005. In January until September the following year, she joined Legal Wise as a legal advisor. That was only after 6 months of her admission. After 9 months with Legal Wise, she resigned and rejoined the law firm until 2008. Ms. Chesiwe did not acquire enough practical experience as an attorney, as her stay in the profession was for about a year. I'm going to read more
Yes, sir.
of the comments to you, but if I pause there, what is your comment to that?
My comment to
Is
that
it factually correct?
my comment to them is that, to that comment is that, like I said already, I graduated in 2002. I've been in the legal field since 2002 till date. So if they talk about experience in the private practice, because I would say experience comes from different levels, different fields. Private practice, family advocate, legal wise, acting as a magistrate, acting as a judge, all those things put together, one would look at its experience that you've gained over the years. It shouldn't be only looked at one point of that specific area, the same private practice. So put together all those things the way I've gone through. I would say it's experience that one has gained through the years. And I mean, experience in any position doesn't come overnight. It happens over the years. You get better as you stay longer in any space, and your experience improves as you go along.
Then if I may proceed, and again, I'm not going to read everything. A lack of practical experience in the practice of law shows itself in her judgments. And then they quote 3 judgments in particular. And in respect of the last one, they say, in the case of Gianni versus the Road Accident Fund, it is very difficult to deduce if she understands application of general contingencies in cases of loss of income. Is that a fair comment?
It's a fair comment because if one look at the dates of those judgments, it is early in the year. I think early 2017 thereabout. So when you look from 2017 early in the year down to last year December, one has improved within that year a little bit better. So like I said, writing of, for example, when I was in Pretoria, I spoke to some of the senior judges and asked them with regard to writing of judgments, how does it improve? How do you get better with time? And they said, well, for example, you can't get it right overnight. It takes time, you build it up over the years.
And then just 2 more quotes. As it appears in paragraph 6 of her JSC form, Ms. Chesiwe has not been employed since 2016. This calls to question how she's been called to act when she is not in any form of practice. And perhaps you should comment after I've read the last part.
Yes, from 26.
Let me read the last part and then you can comment on both. BLA does not at this stage support her appointment. This decision was very difficult to arrive at since BLA stands for support of women within the profession and the judiciary. We are of the view, and this is the important part that I want you to comment on, we are of the view that if we support Ms. Chesiwe at this stage, we will not be doing her any favor, as she will be out of her depth when required to deal with complicated cases. There's 2 issues, the issue of employment and then that you'll be out of your depth at this stage.
The issue of employment, as I said, when I left in 2015 December to join acting, I've been acting since then to date. As a result, it was difficult to be in any private practice because you will not be at that practice at all because you will be at the High Court all the time. For example, during recess, I have part-heard matters that I must complete. So in any practice, I wouldn't have been available at all at that practice because I was acting continuously for these 2 years. So it was difficult to be in any practice because even if I was at a practice, the practice would have felt you are never here, so what's the use, you are keeping you here. So because of the continuous acting of 2 years, it made it difficult to be in any practice. And the second part, if I may get it again, you said was?
That they say they will not be doing you any favor to support you, as you will be out of your depth when required to deal with complicated cases.
In that case, I would say it's not something that I will agree with the BLA, because in any situation, for any person, I mean, we all know through life you learn as you go. Any challenge that comes your way, if you are prepared to face that challenge and resolve it, then there's no need to be discouraged that you cannot do it. Complex issues or complex matters do come, but you will have a way of resolving and sorting them out. So if I look back, the past 2 interviews when I came here, BLA supported my applications. They didn't have a problem then. And I would believe possibly the past 2 years maybe, chances are the judgments might not have been as well improved as now. Because fortunately last week I received a message from the Johannesburg law firm that made me aware that there's a judgment I wrote in November last year, 2018, that has been reported. To me, it's a sign of improving. It means there's improvement as you go along. So the issue of depth and complex, for me, it shouldn't be an issue. It shouldn't deter a person if there's potential for the person to go further.
Thank you. My last remark. You,
No, Valenti.
if I may be permitted, I will. If not, I'll stop.
Yeah, there have been too many though, Commissioner.
It's the,
You
it's the
went
same quotes.
you went beyond 3 even.
Okay. Thank you.
yes.
I'll stop there.
Thank you. How does it work where you have acted? Do they give you matters that they know you don't have the experience to handle? Or do they give you only matters that the JP knows you would be able to deal with?
I believe,
I'm trying to understand the depth complexity issue
I
out
believe-
of your depth issue.
yes, I believe CJ, when the JP allocates files, the JP knows probably all the strong characters of every person. Or where's your strength? But with time, obviously, as you are longer in the field, obviously when I start my first term, it would not be fair to be given a complex matter because you are still learning. But as time goes on, 4 or 5 years down the line, you will be given complex matter because your learning process is over now.
Yes.
And in any event, as a judge, you are learning forever. You will get matters forever. So you'll be forever learning. I mean,
Yes.
you go into your retirement, some of the judges are going to your retirement and they tell you, I'm still learning.
Yes.
So the issue of depth and complex, I don't agree that it should be an issue that should deter a person from achieving what the person wants to achieve.
Well, I sought to understand it because I thought in every court you make sure that people don't deal with matters that they are not able to handle. But anyway, Commissioner Singh?
Thank you, Chief Justice. I've been covered by Commissioner Fourie on the BLA comments. Thank you.
You're excused, ma'am.
Thank you, CJ. Thanks for the opportunity to come.